Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 65, The Times They Are a Skintillating.
This Week in Law is brought to you by Audible. For your free audiobook, visit audiblepodcasts.com/TWiL.
Hi, this is Denise Howell, and you're tuned in for This Week in Law, episode 65. Welcome back to the show. We have two wonderful newcomers on the show, folks I've been very excited to have join us and have been juggling schedules to make it work. First, professor at New York Law School, Professor James Grimmelman, expert on all things Google Books and on many, many things related to technology and law. James, it's so good to have you on the show.
It's great to be here.
Wonderful to see you again. And also someone who has been an influence on my studies and learnings about technology law for a long, long time, Doug Eisenberg from gigalaw.com. Hi, Doug. Welcome to the show.
Great. Thanks for having me, Denise.
Wonderful to have you. And joining us again, Evan Brown from internetcases.com. Hello, Evan.
Hello. Good afternoon. Happy Friday. It's great to be here as always. Thanks for having me.
Happy Friday to you, too. So although we have not yet heard from our friends at the Supreme Court about the Bilski case, the patent case that they considered this term, we did hear this week about a case involving police officer Kwan's personal and somewhat sexually explicit texting from his department-issued device. And what the court told us about this, I guess, was no real huge surprise, but it's good to have some guidance from them on these issues, is that when you are using a work-provided device, such as the pager in question here, you have no real right to keep your communications there private. And the way that they got to that decision, they didn't really full-on address the privacy issues. They addressed this under the Fourth Amendment, and the question was whether the search that was done in obtaining the transcripts of these texts from a third-party provider, whether that search was reasonable under the Fourth Amendment, and the court found that it was. Evan, what do you think of this decision, and what do you think its impact is on the way people use their technology for both work and personal purposes?
It could be one of those decisions that's easy to overgeneralize or to apply it in too many contexts. It's relatively limited on its facts, and the court is very clear to say that it is making certain assumptions that are very specific to this context. Probably one of the biggest assumptions that the court is making here in its legal analysis is that they were just assuming, for the sake of argument, that Kwan did have a reasonable expectation of privacy in these text communications. So I think one of the most important points to take from the case is that the decision does not stand for the proposition that an employee has a reasonable expectation of privacy in his or her electronic communications. It also doesn't mean it doesn't mean one way or the other. We just don't know. The case doesn't tell us that. So another way that it's pretty that I think it can be largely limited in light or in the face of a desire or a tendency to overread the opinion is that it applies just with a government employer. And this is one of the things that I expected the case to be because the court generally doesn't answer questions that it's not asked to opine on. So we're limited here really with the holding here that's applies only to government employees. And we learn a little bit more the contours of this test called the O'Connor test, not to be confused with the former Justice O'Connor, but a Supreme Court opinion from 1987 that set forth kind of the standards, or there was a plurality of the court, 4 justices set forth this test as to when it's okay to search the stuff of a government employee. And we don't learn a whole lot more detail about it. The court gets around the important issue or the intriguing issue of whether or not an employee has a reasonable expectation of privacy, and goes straight to the second prong of that analysis, namely whether the search of an employee's stuff, whether that be in his or her office or his electronic stuff, is reasonable. And in this case, the court overturned the Ninth Circuit, the Supreme Court holding that indeed the search was reasonable because of what they wanted to do to investigate potential workplace misconduct. And so that's why it was not a Fourth Amendment violation for the police department to look at Sergeant Kwan's text messages, some even the sexually explicit ones.
One interesting aspect of Justice Kennedy's opinion, and he wrote for the court on this decision, and as you mentioned, Evan, the court is usually very cautious in saying things about issues that aren't directly before it, or issues that even if they chose to make a ruling on that point, they're not going to do it right then. In this particular case, Justice Kennedy gave some broad suggestions or context as to the backdrop of the court's decision, if you will, and sort of the cultural norms that are coming into play here. I'm going to read from something Lyle Deniston wrote over at SCOTUS blog for a second to give you an idea what I mean. In one of the more expansive conjectures indulged by the opinion, the Kennedy opinion suggested that cell phones and pagers are now so ubiquitous in society that some persons may consider them to be essential means or necessary instruments for self-expression and even self-identification. That, Kennedy added, might strengthen the case for an expectation of privacy. By contrast, Kennedy went on, the mere fact that so many people have and use such devices and their comparatively lower price now may mean that employees can readily obtain one on their own without using one provided by management, and thus have a personal device for personal communications. James, is this giving you any sort of inkling of where the court might go if it were to take on this privacy issue head on, or do you think it's just sort of covering its bases here?
I read that part of the opinion as really being the court saying, this stuff is hard, we're not ready to say what we think yet because we don't even know. Mm-hmm. The court got actually some fairly embarrassing blogging and press after the oral argument in the case over what seemed like some of the justices' ignorance of the technical facets of how the pagers at issue worked. Mm-hmm. It seemed to be clear from the arguments that some of them had never seen a pager, didn't know what it was. They were confused whether it looked like a telephone where you could get a busy signal if you tried to send somebody a text message while they were sending one, or whether it was more like email. And so you can read the court's opinion there as partly being an attempt to say, we're not really ready to make detailed rules here yet. This is a complicated issue with a lot of technological lines that we're not really sure how to trace. So we're going to punt on this, and here, by the way, are some reasons that we think it would be a good idea to punt. We can introduce plausible sounding conjectures that would go either towards privacy or away from it. And here, look, this is hard. You can't expect us people to make this decision yet.
Right. So where this might come before the court again is if you had another government-issued device, say, or employer-issued device, if we get out of the simply government arena there for a second. And as was, I think, the case here, the facts are sort of muddy on this, but I remember there being some confusion for Officer Kwan about the guidelines for use of this device. There might have actually been some indication that the use of this device was supposed to be for, that it was okay to use this for personal purposes. Or that there might not be monitoring. You'd have to go through the record and check me on that because I'm kind of muddy on that. But I remember there was some confusion there, and you can envision a case where perhaps there simply isn't a statement by the employer as to whether you should be on notice that you're being monitored. So you could envision an employee being supplied a device and perhaps even encouraged to use it for all purposes, so that they could be, as productive as possible with their time, and then having the privacy issue come up again. Doug, do you have any thoughts on all of this?
No, except that I do want to reiterate a point that was made early on, that this is obviously in the government context, but the broader interest certainly, I would think, is in the private employment context and what lessons can be taken from the case, if any, for employers and employees. And maybe there aren't a lot of lessons to be taken, except the overall notion that employers have a broad right to monitor and obtain information that from devices that their employees are using. In this case, in fact, as you said, Denise, I believe there was an agreement or a policy that was in place. The scope of that policy may have been a bit unclear, but I think it reiterates, and I'm not an employment attorney, but it certainly, I think, underscores the importance in the private sector of an agreement, a proper employee handbook, for example, that sets the employer's rights with respect to laptops, cell phones, smartphones, pagers. I don't know who uses a pager anymore, and I don't think I ever encountered a busy signal on one, but as was mentioned, that certainly was an interesting exchange during the Supreme Court's oral argument. But in general, I think the broad lesson to be taken here for employers is that under the right circumstances, even if not specifically on the facts of this case, but generally employers have a right to access these devices, and employees should conduct themselves accordingly.
It's interesting how that whole issue comes into this case here, because, remember, as I said early on, the court avoided answering the question of whether or not Quan had a reasonable expectation of privacy, but there was still a fair amount of discussion as to what his understanding was. And I found it very interesting that there was also a sentence in there where Justice Kennedy said that it was also relevant what the employer thought, what the employer would think if it were going to, be examining these text messages and, go in there and expect only to find work-related stuff. The reason that I find this so intriguing here is because for the third or fourth time now, we're not talking about the whether there was a reasonable expectation of privacy, but they brought this discussion of what Quan thought into the question of whether or not it was under the reasonableness prong, whether this search was reasonable, and it went to the point of whether it was so intrusive that it was unreasonable. And I found that particularly intriguing because it's almost as if they're bootstrapping the question of what it means to have a reasonable expectation of privacy. I guess shoehorning is the idiom I'm looking for. And they're shoehorning that into this inquiry without addressing it, but still making it relevant as to what the policy may have said, what his supervisors may have told him in meetings, what it is, that led him to have a particular understanding as to what the technology was to be used for.
Yeah, the reason this case and cases like this are so interesting to me is because of the blurry lines between our personal and professional selves, and how those lines get blurrier and blurrier with technology. And I don't see any sign of that stopping. And so I think it's very important to look at these kinds of developments in the law as they come out, and to keep this case and ones like it in mind. I mean, obviously people, if you want to be as safe as possible with all of your communications, then yes, you should have a very distinct separation of church and state, and do all of your personal communications in one way and all of your professional communications in another and on different devices. But in reality, it doesn't work that way. It's never worked that way for the last at least 5 or 6 years, and perhaps longer than that. And, I think that that tension is why we continue to see cases like this, and that it continues to be an issue that's going to hang out there. So any final thoughts on this before we move on, James?
I mean, the issues that the court dodged in the case, and some of the issues that came up in the lower court's opinions before it got to the Supreme Court, and they sort of winnowed it down, would have addressed some of the issues that go even beyond the employer-employee context. You've got cases in which somebody sends messages through a third-party provider, through email, through text messaging. Mm-hmm. And there was a lot of attention on the case because people thought, oh, the Supreme Court might weigh in on your expectations of privacy or your statutory rights when the messages pass through some other computer company's servers. And just based on the way the case got presented and the issues that came out, it wound up turning entirely into this employer-employee case, which is something very different. And I think there are a lot of people in the privacy community who feel like they dodged a bullet with this opinion, because the Supreme Court could have come in and said, oh, you have no rights when it passes to a third-party servers. That question's still open legally.
Mm-hmm. So, the way that works now is third parties do respond to subpoenas, unless there is, I guess it's sort of on a case-by-case basis. We certainly have had some high-profile incidents where Google has refused to turn over information that has been subpoenaed by the government, for example. But, it very routinely turns over other information when it is subpoenaed. So James is right that that's a lingering issue out there that again, we don't know how that's ultimately going to come out when this court, which is the one who gets to decide the scope of our privacy protections here in the United States, tees that issue up directly and head on. Doug, any comments from the Gigalaw community on any of this?
No, I don't disagree with much, if anything, that has been said today. Denise, the point you just made a moment ago about sort of blurring the lines of the tools that employees have at work are not used exclusively for personal or professional purposes for the most part. So whether you're using the telephone, the landline that sits on your desk to make a personal phone call, or whether you're using your own personal cell phone to make a business phone call, the lines certainly are blurring. And so I think, if anything, this issue is, as you point out, which has become more of an issue in recent years, is only going to grow in importance. And I don't think that this decision from the Supreme Court, while interesting and closely watched, like any Supreme Court decision, frankly, is the end of the road by any means as far as these issues are concerned.
Right. The other thing that occurs to me is, as everything moves more inexorably toward the cloud, what device you're on matters less and less. It's, what you're doing with that device at a given time that is really the pertinent inquiry. So, you could envision a day where your expectation of privacy might turn on how you logged into whatever resource you're using, whether you're connected to your firm's Citrix server or whether you're, out on the wild, wild web or what have you. This didn't involve the internet, but not directly anyway. But I just think that whole aspect of moving data off to third parties, which seems to be something that is not going to put on the brakes anytime soon, will also shade this discussion going forward. So interesting development there. Oh, go ahead.
No, Denise, I was just going to add, and of course, I think what goes without saying, so I'll say it anyway, in your comments, is that, a lot of these conversations, if you will, these communications, live on. This is not, 1970s and Watergate, where, you might unearth a reel-to-reel tape recording. Here, for the most part, certainly text messages and emails, as well as all sorts of other communications, will live on. And so the communications themselves, there's not only a question as to what is private and what is not, but if the communications aren't even there to capture in the first place, it's quite different today than certainly it was 40 years ago.
There's one final point I'd like to make here, and it has to do with changing norms and the court's willingness to wrestle with those. On the 10th page of the opinion, of the majority opinion, Justice Kennedy talks about how prudence counsels caution in dealing with issues that arise from emerging technologies. And, that's all well and good when we're sitting around talking about it, but, it's the job of the Supreme Court to make decisions. And Justice Scalia, in his concurrence, calls them out on that a little bit. And I think this is really fascinating insight into how Justice Scalia thinks, this little conversation going on. What Justice Scalia says in criticizing that aspect, or that one part of the opinion that he doesn't want to join, he says, applying the Fourth Amendment to new technologies may sometimes be difficult, but when it is necessary to decide a case, we have no choice. Then he goes on to say a little bit later, and then this is my favorite line from the whole case: the times they are a-changin' is a feeble excuse for disregard of duty. So it's clearly fascinating to find ourselves in a situation where Justice Scalia is channeling Bob Dylan to talk about anything at all. But you've got to remember, this is the guy, Justice Scalia, being a strict constructionist as he is, who, why should he be afraid to handle all this? After all, he thinks we all should be living back in 1780 in the first place. All we need is the Constitution. So I thought that was quite interesting to see the judiciary's willingness to tackle the ever-changing landscape of posts along the ever-changing landscape of technological innovation.
Yes, and it is those posts that have been Professor Grimmelman's study for a long, long time. In your bio, James, it says how you study the law governing the creation and use of computer software and how it affects individual freedom and the distribution of wealth and power in society. As a lawyer and technologist, you aim to help those two groups speak intelligibly to each other. So that is a wonderful introduction to having you try and explain to us briefly, if that's at all possible, where things now stand with the rather momentous Google book search settlement, which you have been following and making intelligible as much as it can be since its inception. So can you bring us up to speed there?
Yeah, so the two-word answer on where the settlement stands is in limbo.
Uh-huh.
Now, going back, the context here is that Google started scanning books from major libraries back in 2004, both books in the public domain and books under copyright. And they rapidly got sued by authors and publishers, objecting that scanning books under copyright and making them searchable amounts to copyright infringement. So Google defended on the grounds they've used on the web, saying, we're making a search engine index. We're not showing people the whole contents of the book. We're just making an index and showing them short snippets that let them see which books actually have the term they searched for. That's where the lawsuit started. It looked like it was going to be a big fair use fight. And then 4 years into it, and 3 years into the lawsuit, 4 years into the project, in 2008, Google and the authors and publishers came back with an announcement of a settlement. Google was going to pay about $125 million up front, the majority of which was going to go for the lawyers, but some of which would go directly to copyright owners. That would be paying, in essence, to compromise the claims of past infringement. And then they said, we're going to go a little bit beyond that. Google is going to start selling whole copies of books. Now, for books that are in print and where the authors and publishers have come forward and said, that's my book, then this isn't too complicated, because they can say to Google, please sell this book, price it at $15.99 or $5.99 or whatever, or they can say, please exclude my book. But the really interesting and really controversial part of the settlement is that for out-of-print books and books where the copyright owner hasn't come forward to say, that's my book, here's what I want done with it, Google is going to be allowed to start selling the book. And it will keep its share of the revenue, the 37% that it keeps whenever it sells a book through other programs. But it will pass along the other 63% into this fund that will sit around waiting for the copyright owners to come back. And if they come back and say, yes, oh, that was my book, you've been selling it for the last 5 years, they get to take their share of the money. But if they don't, it just sits there and Google keeps on selling it. So that's the
indefinitely.
It's a very, very complicated settlement.
Right. Is that fund going to sit there indefinitely, or is there any specification for what happens to it, if a certain amount of time goes on?
So initially, it was going to sit there for 5 years and then get divided up among the other copyright owners, the ones who had claimed their books. That turned out to be immensely controversial because it smacked of some copyright owners getting rich off of the work of others. So after some controversy in the fall of 2009, the parties revised the settlement, and among the terms that they changed was the one governing what would happen to that money. They wound up saying, okay, after 5 years, we can use 25% of it to search for you. So we'll use it to actually try to track you down to give you the rest. And after another 5 years, so after 10 years total, it can be given to charity. And the charities will be ones that benefit authors and publishers generally.
Wow. So in addition to being in the book selling and ebook selling business, under the settlement, Google would be somewhat in the private investigation business, hunting down and seeking out orphan work authors.
Well, if you think about it, who has more information than Google?
Yeah.
Exactly. Yeah, it was probably all that data they were going to get from the Wi-Fi sniffing, while they were doing the Street View. That's why they were doing that. Mm-hmm. Track down orphan owner.
It certainly couldn't hurt. James, let's put this in context with what we know of Google's business plans going forward, or at least what are suspected to be their plans going forward. We know that they would like to sell physical books. We know that they have an ebook store opening shortly. And we know that they also plan to, at least this is reported and suspected, that they plan to move into the music arena and sort of become an iTunes-like entity. How do you think that plays into the terms of the settlement and what Google will be allowed to do if the settlement is approved?
So Google's entry into the online books and also the online music market, and the books is definitely confirmed, it'll be happening this summer, is clearly Google's next play in the ongoing three-front war between Google, Amazon, and Apple over media sales. And so the Google Editions store, which will launch this summer, is going to be an ebooks play. And Google's big selling point is going to be, these are books based on the cloud. So you buy the book, and it will work anywhere that your Google account works. You can download it onto e-reader devices that are linked to the account, or you can read it from your laptop. You can read it wherever you go. So that's their sort of technological edge. And the content edge they're getting comes in part from the settlement. They already have partner programs with a lot of publishers, which really work almost exactly the same way that Amazon's partner programs do in terms of, here, we'll get permission from you and we'll start selling your books. You can control the price. You have some say into what happens. Whereas Google, by using the settlement, also gets this source of mostly out-of-print books that others are going to have a very hard time accumulating. So you take what are so-called orphan works, where no one can find the copyright owner. Maybe the author died, and then the copyright got passed on to their heirs, and no one knows where they are, or the publisher got absorbed in a wave of successive mergers, and no one's quite sure who owns the copyrights. In any case, you have these orphan books where no one can find the owner. Well, Google will have, through the settlement, the right to start selling copies of them, and it'll just hang on to the money in case the authors show up. But in the meantime, the Google Bookstore is the only place you can find these books, because anyone else who is going to start selling it would be crazy. Without the settlement's legal protection, you're facing copyright remedies, copyright statutory damages, paying $150,000 per title you try to do this on. There's just no way you could build a bookstore in a legally safe way without the settlement's legal umbrella. So I think Google is maybe hoping that they'll have this really comprehensive collection, including a huge backlist that none of its competitors can really match.
Right. Doug, do you see any sort of issue in the many arms that Google is placing in the water as far as its growing media empire?
Well, I'm just curious to know whether these books are going to be supported by contextual-based advertising as I read them. It seems right now that books are one of the last few places you can turn without facing advertising, now that obviously we're accustomed to it in magazines and newspapers and TV and radio and websites and sides of buses and sides of buildings and everywhere else. It's nice sometimes to actually take a book and not be bombarded by advertising. So obviously when you think of Google, those who understand Google's business somewhat. Not that I profess to have any great insights, and understand that their revenue is based largely upon advertising. The other point I guess I would sort of make is just because Google enters a market doesn't necessarily mean that Google is going to be successful in that market. It's also important to remember that Google has not always been around as well. So my crystal ball isn't working very well, and I'm not quite sure what the ultimate impact of this will be, but I think from the consumer's standpoint, that all of this is a good thing. Now that you can get your media in more formats than you could in the past, and even on an iPad, for example, you can currently purchase books through the Apple iBooks program or through the Kindle app, among others. And I suspect there will be a Google Books app. Interesting if Apple approves it for the iPad. So from the consumer's perspective, I think this is all a good thing. From the copyright owner's perspective, of course, that is the authors. There's a potential upside and there's a potential downside. But this is all somewhat new territory. Obviously, the issues of copyright law and copyright infringement are not new, but certainly the issues that are being raised are new. And I think, unfortunately, I would say we have to take a little bit of a wait and see approach.
Right, Evan. Settlement, and but perhaps before we go to Evan, we should have James tell us when the limbo is expected to end.
So the settlement attracted, as one might expect, enormous opposition, both from Google's commercial competitors, Microsoft and Amazon, Yahoo, and the like filed briefs against it, and also concern from copyright owners, some of whom felt that Google shouldn't just be able to impose this deal on them through the class action, that it should have to ask individual permission from each and every person and company whose books it wanted to put in the store, and also from various public interest groups that were concerned with things like privacy. Also drew some support from groups that liked the expansion of access to books, from Sony, which was going to sell books in partnership with Google, from various other groups who were excited by this huge digital library. So all of these people filed their briefs and their comments, and the court held a hearing on whether to approve the settlement in February of this year. At the end of the hearing, the judge, to no one's surprise, said, well, this is a complicated case. I'm going to take it under advisement. And that was the last we heard about it. That was, months ago now. And Everybody's just waiting for Judge Chin to go ahead and issue a ruling. And no one's really quite sure when that's going to be.
And to
make things even more amusing.
Didn't he get called up to the big leagues? Isn't he on the Second Circuit now?
Yeah, in the middle of it all, he got appointed to and confirmed to the Second Circuit. So there's also the possibility that he might just hand the whole thing off to some other poor judge who has to come up from scratch on the 1,000 filings in the case.
Yes, so this limbo could be a long one. Folks remember Jarndyce versus Jarndyce from the Dickensian era. It's starting to take on those overtones. How about this photographer's suit against Google, which relates somewhat to the book search project because it deals with the images in those books? It's not impacted by this settlement, correct? It's going forward on its own at the moment?
This is one of these weird, confusing spin-offs from the settlement. Officially, the settlement doesn't include the pictures if they're by somebody else than the copyright owner in the book. And so it's people who license images to put in books or you license a photograph or commission a chart, then some of these things may not be covered by the settlement. And presumably that means Google was planning to go ahead and just blank out those pages when it sold the books. Well, the photographers and various other visual artists decided, we're not part of this. We're not actually going to get money out of the deal. And yet, because this thing is going to shape the whole publishing industry and set the terms which Google can get books, if we don't get on this boat, we're going to be stuck back in port. So they actually, I think, want to be part of the deal. And they filed their own lawsuit basically just to build up enough negotiating leverage to get a seat at the table. Hopes that they can strike some kind of similar deal with Google or tilt the terms of this one a bit more in their favor.
All right. Well, thank you so much for bringing us up to speed there. As you say, it's a terribly important issue and does have the capacity to shape the whole publishing industry going forward. So we will be watching closely for the judge to go ahead and decide on the terms of the settlement. We should say, too, that this is their second effort at a document. I think you did mention that, James. And presumably there could be more going back to the drawing board that would be specified by the court. So I don't envy the folks who are involved in this litigation and the business plans that they have sitting in their hoppers trying to be made into reality. But this is where we stand right now. Also on an interesting copying and copyright issue, although the privacy overtones are what have put it in the media spotlight lately. And this will be our tip of the week as well for the week of, let's see, today is June. Goodness, I've completely lost track of the date. It's the 18th today? Yes, June 18th. So our tip of the week right now is if you are using a photocopier at your business, or if you are going out to a third-party photocopy shop, such as Kinko's, you might not be aware, if you have not tuned into the fairly recent CBS News story on this front, that photocopiers are being manufactured these days with hard drives on board, and that the things that you're copying are actually being stored and live on with the copier long after you and your piece of paper have gone away. So as I mentioned, CBS News did a story on this. Actually, our sister show, Security Now with Steve Gibson, took a brief look at this in their 246th show a few weeks ago. So if you're looking for more information on this, do go see what Steve and Leo had to say. But we have a link in the show notes here to a New York Times blog article on why photocopiers have hard drives. And it was an eye-opening experience for lots of people, including Carl Sussman, who emailed me this week about this and is in the insurance industry, because of the ramifications for many, many industries, such as health insurance and healthcare in general, of compliance with regulations that they keep customer or patient data private and that they maintain it under certain standards. And this seemed to be a great big hole in the compliance strategy, that a lot of data was leaking out to these hard drives. And then, of course, a copier might get, if it goes away, to be serviced, if you're simply leasing it, if you sell it. If you're not aware that the hard drive is there, it goes with the copier and could be recovered and that data harvested off. And you can imagine all kinds of nefarious things that could happen, such as people's social security numbers, driver's license numbers, et cetera, could be put out into the public that way. So I just wanted to bring this up for both the privacy considerations and the copyright considerations, and discuss how that comes into play too, because obviously copy machines have been subject of various targeting in the past over their ability to do what they do. And obviously they've been blessed by the courts as a technology that we need in our society, or at least traditionally have needed in the world of things done on paper. And here we go with a bit of technology that nobody knew were present or came along. Again, the times they are a-changin', said Justice Scalia. That just changed the way they work a little bit, and you've got a whole host of new considerations. Evan, what do you think about both the privacy and copyright implications of photocopier hard drives?
I was going to say something about how horrified I am recalling what might be on the hard drive of the copy machine that, where I used to work when I would come in after, drinking a bunch and making various photocopies of body parts. But I'm not going to say that because that never happened. It was just a story. This is one of those things where,
I would say you've waived your right of privacy in those sorts of copies.
But it was, in the middle of the night. Yeah. Anyway, this has been on my radar screen for a while because, I'm involved with our firm's electronic discovery response team here. So this is, it's always our mission to go out and find all the sources of electronically stored information. So, the recent increase in awareness of all this, or the resurgence, renaissance. Or I guess it's not a renaissance because it just seems like now this is something people are realizing for the first time is kind of interesting because this stuff is there. You've got to be thinking about where sources of data are. From a legal standpoint, from a privacy standpoint, it would seem that it's one of those situations where the current frameworks and the current systems or legal, the various things that would govern how an enterprise is supposed to treat data would apply. If you're a hospital and you have a photocopy machine and you're making copies of patient records, well, HIPAA is going to cover that. So it's more of an awareness issue, knowing what type of technological infrastructure you have, how your copy machine works, trading off this risk of a privacy breach in favor of convenience, as the New York Times article tells us. I think it was New York Times, right? I didn't see that on the Pulse app, by the way. Seeing how, just being aware of what things are there and, handling it accordingly. Just know thyself.
Right. This looks like something that the states are starting to pay attention to. I think I saw a couple of articles about the state of New Jersey actually having some pending legislation on the topic. James, do you think that having a hard drive on board a copier changes the copyright texture of the acceptability of these devices?
Not a whole lot, because after all, the whole copyright issue comes out because this thing makes copies.
Right.
The copyright holders are already upset about whatever are infringing uses, and most of those are going to be treated as clearly infringing. And that's the fault of the person who pushed the copy button on the machine. Okay, so that person who decided to go and make a photocopy of a whole textbook. Okay, so there's also a copy stored on the hard drive. Well, that's just they're just adding to the problem. But no one was really disputing that certain kinds of copying were going to be treated as infringements anyway. So it increases sort of the fears from the copyright owners. I don't think that they're really thinking about a lot of market harm from systematic mining of copy machines' hard drives. This is not, I think, if I'm a copyright owner today, at the top of my list. I'm much more worried about file sharing sites, much worried about distribution networks than I am about, the fact that somebody who goes to e-waste junkyards and starts whipping hard drives out of copy machines might happen to come across a few pages copied from my book. Mm-hmm. So I don't think it really changes the copyright calculus all that much. It just, another instance of the fact that in a digital age, copies multiply just really surprisingly. You can be shocked at what kinds of technology are actually storing a copy. It really is easier to make a copy machine that has a hard drive and makes those extra copies than it is
I
to
think
make
even
one without
pens have hard drives of some, or flash drives, memory of some kind these days.
Yeah, and there's this great line from Harry Potter: just never trust something where if you can't tell where it keeps its brain. And increasingly, just things around us have brains in hidden places that we don't know about.
I was just going to add that I agree. I don't think the copyright issues are impacted in any way, because the important issue here, as the Supreme Court said quite a number of years ago in the Betamax case, is whether the device, in this case the photocopier, is capable of substantial non-infringing uses. And certainly, while a photocopier, indeed, as James said, exists for the purpose of making copies, just because something is copied does not necessarily mean that it arises to copyright infringement. So whether there's a hard drive or not in the photocopier is still capable of substantial non-infringing uses, which is what the Supreme Court blessed quite a number of years ago. What's also sort of interesting in the news this week, in another device as well as photocopiers, I believe TechCrunch had a story about how the HTC Droid Incredible smartphone was actually capturing images of pages viewed on the browser. This is one of the popular Android phones, and those snippets could actually not be erased even by a hard reset. So whether the copying is occurring in an old-fashioned photocopier or in a brand new Android smartphone, everybody's certainly right that these copies are being made. I don't think there's much of a copyright infringement issue, but certainly, consumer beware.
Doug, what do you think about the duty, if any, on the copier manufacturers to advise people that this is happening? I mean, it seemed to strike a whole lot of people by surprise. Legislation may result. Do you think that there should be a duty to inform that, oh, by the way, there's a persistent copy of the thing that you may be assuming is transiently simply being transferred from one piece of paper to another?
Well, I don't know that there's a duty in the sense of could a photocopier manufacturer incur some type of vicarious or contributory liability for infringement by providing the technology that enables that copy to persist. But
how about the privacy aspect, though?
Well, I certainly don't think there's anything wrong with disclosing that fact, and I think as well that sort of like in the software programming field, one person's bug is another person's feature, and I suspect that these hard drives exist to enhance the photocopying experience, so to speak, whether it's by speed or otherwise, and so. I think, as I said, there's no harm in the manufacturers touting this, and perhaps they can even do so as an advantage rather than as a disadvantage. But like anything else, the more publicity it gets, then the less need, there ultimately will be for warning others. It used to be, perhaps folks were selling their computers without giving much thought to what was on the hard drive. Or at one point in time, of course, people were, selling used computers and there were no hard drives on them. It wasn't that many years ago. So, now we have hard drives and photocopiers, and I think, at some point, probably in the near future, it will be well known that this is how they work.
Let me float a hypothetical by you guys as a way of shortly introducing our ad for our friends at audible.com, because I have a book recommendation there that is relevant to this hypothetical. And that is if you were, for example, somebody who were interested in the sci-fi TV series Merlin, and you were impatient to get access to the second season of that show, and you were to go out hunting online, not via BitTorrent, because you might be aware that there are lawsuits being brought against people using BitTorrent to access unauthorized copies of copyrighted works. But you simply visited our friends at Google, who are having their own share of litigation about what's available on YouTube and whether they're taking relevant steps. And you were to find that indeed you can view that show and many, many other shows in chopped up 10-minute increments that people have taken it upon themselves to upload. And, Google does its best to try and squelch each one of those as they come along, but they don't do a comprehensive job. So if you're willing to watch your shows chopped up into 10-minute increments, you might well find a good deal of it available on YouTube to this day. Now, in the peer-to-peer file sharing cases, there's no question that the people doing the sharing have some liability, as well as we've seen the courts hold the third-party repositories and facilitators of that sharing responsible too. But here we're not talking about anybody who made a copy. We're talking about someone who's simply using a service. Do you think that there's any sort of liability that could attach for simply using a service in the way it functions at this time, even if there are complaints about the way of that function? And if you don't think that there's liability for that, does the making of a copy actually have a significant role here? I mean, that's what we hang our hats on in copyright law for finding liability. But whether you're gaining your show from BitTorrent or P2P or some other nefarious means where liability certainly would attach, or whether you're simply consuming your 10-minute chunks on YouTube, your experience is much the same. So why shouldn't liability attach in the latter case? Evan, do you have any thoughts on that?
If we could just clarify one thing on the hypothetical, there's no local cache copy being created, right?
Nope. You're simply going to YouTube, using the search function, finding whatever it is that's been posted up there that probably shouldn't be there. And, maybe the viewer knows that or not. Maybe they simply know, hey, it's here, I can watch it. What do you think about that?
Well, the difficulty that arises is that there's, I guess, you've set up the hypothetical so that factually there aren't one of the elements or one of the rights under Section 106 of the copyright being implicated here. There's not a copy being made. There's not a distribution, I guess. Maybe there is. But it sounds like what you're trying to say, that there really is nothing that's traditionally considered copyright infringement. So that leads me to think in the situation here of what Ernest Miller said a few years ago in a law review article, and I love bringing this up whenever I can, that copying is a poor indicator of an intent to infringe. So that is kind of a mantra of certain variations of copyright reform, saying that we really got to look at the right of access, or the right to view something, to get the content as the touchstone for infringement liability, rather than this notion of there being a copy made or distributed or something like that. So I like the hypothetical in as much as it implicates those issues.
Mm-hmm. James, do you think that copying is really that pertinent of an inquiry, given the times they are a-changing, and that you can access things in various ways, whether you copy them or not?
I think I agree with Evan and with the Ernest Miller sentiment that he quoted, that copying is really a poor proxy for the things that we care about in protecting the interests of copyright owners, that it's really about distributing something to the public and reaping that commercial advantage. But that said, I think even on the facts as you've given, I want to fight the hypothetical a bit, because YouTube videos do make a local copy of substantial parts of the video. Like that red bar at the bottom of the video is showing you how much of it has been downloaded to your computer. And under the MAI case, that video is almost certainly being stored in your computer's memory long enough to count as a copy. Now, under the recent Cablevision case from New York, there's a question of how long it has to stay there before it starts to trigger the Copyright Act. But, I think if you're a lawyer who's going to try and fight this one on behalf of the copyright owners in Merlin, I think you could actually make out a decent case on the statute as it stands against that person who thinks they're only just streaming it and not making copies.
Right. Doug, any thoughts on this?
No, I agree that just because you don't believe you're recording it doesn't mean that a copy is not being made. It's also interesting as you look at the Section 106 of the Copyright Act, ways in which copyright infringement can occur, or at least the exclusive rights that a copyright owner possesses, as Evan pointed out. Copying is just one way in which infringement can arise, and infringement can also occur by, among other things, preparing derivative works, which might not seem to be the case in your hypothetical, but also distributing or publicly displaying the works. And so one of those other Section 106 factors could potentially come into play here as well. But of course, there's always an interesting fair use issue to be applied in these circumstances, and somebody who watches 10 minutes online may actually have a positive impact upon the ultimate value of the work. To sort of summarize one of the fair use factors. And so, whether or not one of the 106 factors is violated, I think there will always be an interesting fair use issue to evaluate.
All right, so that was sort of a long setup to our Audible recommendation of the week. But the existence of the Merlin show reminded me that there was a great series of books also told from the standpoint of Merlin himself that I read. When I was younger, I used to read The Lord of the Rings almost every summer from the time I was 8 on. But I found that as I got older, I would get through them quicker and needed other things to read. And someone gave me the series by Mary Stewart that is all about the backdrop of Camelot and her own fictional spin on Merlin and Arthur's birth and life and death. And the book that I'm going to recommend on Audible is the middle book of 3. It's called The Hollow Hills. You could pick up any of them and read them out of sequence because they provide the context of the whole series. And this one actually is set when Uther, Arthur's dad, is still alive, and Merlin is helping raise Arthur, the boy. The Hollow Hills by Mary Stewart. It is abridged on Audible, so you can get a good flavor for the series, and you can have it for free when you go to audiblepodcast.com/TWiL and go ahead and pick that as your pick to get started with Audible. And after you do that, you'll be signed up for $14.95 a month to get a credit for another book. So if you're interested in the Arthurian legend, you'll find much to explore on Audible, including a 31-hour complete version of the Morte d'Arthur, the original, one of the original texts for the whole Arthurian saga. So there's lots to check out there, but I really enjoyed the Mary Stewart books for the same reason that I think the Merlin show is popular. It's sort of a very rich fictional spin on the legend told from the standpoint of Merlin himself. So check out The Hollow Hills on Audible and follow Audible on Twitter at audible_com for even more recommendations. Thank you, Audible, for your support. Folks, I wanted to talk next about, we've talked about the various ways that lines blur when technology comes along between one's personal and professional lives. And I think there's a lawsuit pending that helps illustrate that as well. And it has to do with LinkedIn and Facebook and other social networking platforms, and how the use of those communication forums can actually perhaps violate a non-compete agreement in the employment context yet again. Evan, did you take a look at this case, and do you have any thoughts on it?
Yes. This is the one in Minnesota, right? About the use of LinkedIn. This is, interesting because it implicates the new technology. It's one of those things where I don't think that there's much difference substantively in something like this than any other kind of breach of restrictive covenant type of case in an employment context. The thing that makes it most intriguing is the fact that it was LinkedIn, and the ease of communication was made easier, and makes for much more scintillating Is that the word I'm looking for?
No, it's not at all. Scintillating.
That means like sparkling, right? Salacious.
Skintillating was what you were doing with those copy machines.
It makes it more interesting. Let's just say it that way. We'll be all vanilla about it. It's the medium that makes it interesting, not the substance traveling through that medium that makes it any more interesting, I think.
Larry Dignan, writing over at ZDNet, wonders whether non-competes will be drafted to specifically include social networking restrictions. James, do you see that in our near future?
It's like, wow. I mean, it certainly makes sense that companies will want their non-competes to tell the employees that, no, you can't call up our employees after you leave, you can't send them emails, and no, you can't send them instant messages over your favorite social network. And this sort of makes sense. The medium there is almost irrelevant. It just happens to be a place that has their professional contacts in one place. I would worry about companies trying to say that you have to sever all contact, so that, if you quit, you have to delete your LinkedIn account or delete all of your connections to anybody that you knew while you were working for us. Like, that strikes me as a worrisome trend. And I'd be kind of afraid of any employer that told me that we're going to take your social network profiles hostage so you won't quit.
Mm-hmm. It seems to me like that is something that employers and employees should perhaps be addressing at the front end of their relationship, as opposed to at the back end when someone is departing, whether voluntarily or otherwise. Doug, what do you think about this case, and where do you see this going?
Well, I think what's interesting is, especially on Twitter, I've noticed that you see a fair number of accounts that identify not only the person with the account, but also the person's employer. In other words, their name plus the employer's name. And I think what's interesting in that is it may be an attempt by some of the employers to tie that particular account to the employer as much as to the employee. So that, in other words, once the employee leaves his or her current job, there's really no benefit or not as much benefit in the employee continuing to use that same account. But I'm not surprised if there are, or if there will be, agreements between employers and employees, obviously, as to what you can and cannot do via certain social networks, not only during your employment, but after your employment. And in many cases, those types of activities may be covered already by some of these agreements. Contact, for example, in the past, may have meant, don't telephone somebody or write them a letter. But certainly, contacting somebody by email or by instant message, or even poking them or liking them on Facebook, may be covered by that type of language that already exists in these employment agreements.
Right. Let's move on to talking about. I thought this was a pretty interesting little thought piece from Shelley Palmer on the topic of the tiered pricing that AT&T has rolled out recently in its data plan, moving away from offering unlimited data for devices such as phones and the iPad. And Shelley had this sort of speculative piece that he wrote called "Will Tiered Pricing Lead to Proxy Nets?" And his premise was basically that there, given that people will want to move away from using data services because they become so expensive, cell services and other third-party providers of how you access information, that it would be relatively straightforward and simple for one to leverage one's social network developed online and then move it into a private arena. So once you have all your contacts in place, there could readily be Shelley app written that could then connect all those people up directly, so that they, if their point were to share data among each other and information, that they don't necessarily need to reach out to any other sources or nodes than their own local data stores. And so the interesting impact on that, and I do believe, if you read the book Darknet, that you'll see that this sort of thing goes on today in the way of staying under the radar of folks looking for copyright infringement. But I guess Shelley's worried that it would take off and become widespread in response to the economic concerns of the costs of accessing data. Evan, did you take a look at this, and did you think it was something that was realistic?
It reminded me of the distinction in formal logic between the possibility of something being valid and something being true. Something can be valid but not true, well, I guess everything true is valid. But this is an example of something that seems valid, what he's talking about here. This reaction to the constraints on bandwidth is one way of characterizing it, I guess, is there becomes this network that is somewhat off of the grid because it's not connected to the big pipe, and so content is being distributed between these within this proxy net. It makes sense that it could turn out this way. I just don't think it will, which is why I think that it's not true, even though it's valid. Because if we look at things historically, there tends to have been an evolution of things to match, or I guess broadband capabilities will expand to match the demand. 15 years ago, we had the pleasure of using 28K modems, and the notion of the bandwidth that we have now, even on a not on a 3G network, any kind of mobile broadband network, that type of bandwidth on a consumer level would have been unimaginable then, or at least quite nice to think about. So, because bandwidth availability will continue to evolve to meet the demand better, I don't think that we'll have the ecological conditions arise that necessitate the development of these proxy nets that Palmer talks about. But it's really fun to think about nonetheless.
James, you've been following sort of darknet activities for quite some time, going back to LawMeme, when folks were, I would call that sort of the marriage of Slashdot and the law, which you were the editor of, courtesy of Yale and its Information Society project. Do you think that these things are flourishing and bound to flourish more as people move away from wanting to spend money on their data and simply want to access it from where they know it is?
And I think that this sort of proxy net or this sort of peer-to-peer mesh networking style hookups that have these incidental, pretty serious effects from copyright holders' perspectives. Mm-hmm. I think that if that happens, it's probably going to be for exactly that reason, that people want to share things really strongly locally. And it's not even so much the cost of bandwidth they're concerned about as just the comparative slowness of their connections to the internet compared with a high-speed local link. Or it would be something like their desire specifically to evade monitoring. They know that if they share music with their friends, by exchanging stuff over these local proxy nets, then they're not in danger of being caught. So I think really this may well be something we could see happening, but I don't think tiered pricing is likely to be the driver of it if it happens.
Right. Doug, what do you think? Will people become more provincial in their consumption of data and look more to their networks than the net at large?
Well, first thing I want to say to Evan, I think those groundbreaking 28K modems were pretty fast. I recall the 300 baud modems.
Right. See, it's all an evolution. There was always the slower predecessor.
Yeah, exactly. I remember when it was a big leap from 300 to 1200. So, but I also remember in those days as well, which predated the web certainly, when there were proprietary services like a CompuServe, back in the early 80s were charging $6 per hour for connectivity. Then we went to sort of a flat model, and I think AOL was one of the earlier ones to do that. So instead of paying by the hour, you're simply paying by the month. And so what we're seeing now is sort of an example of everything old is new again, and so we've become accustomed to sort of all you can eat for one flat price. But I certainly know in my house I don't get all the water or electricity or most of my other utilities for one flat fee. So I think what AT&T is doing is certainly understandable, but obviously once you've gone down one path, it's sometimes difficult to start to go down a different path. As far as accessibility and sort of the universality of where your data is, what frankly sometimes scares me about the Facebooks and the LinkedIns and the Twitters, and I've heard of something called MySpace, is that these are also proprietary networks, and it is not like the web or email. And so if you're putting all your eggs, so to speak, in one of these proprietary baskets, and all of a sudden the basket goes away, either because of an interruption of service or because of economics or something else, then you're at the mercy of one of these other services. So I think there's certainly some advantage in having your own sort of local access and networks as well, perhaps in addition to these proprietary services.
Well, with James and Doug on the show, it's very straightforward to do our resources of the week for TWiL 65 here. One is gigalaw.com. Doug, why don't you explain to us a bit about Gigalaw and how long it's been around and what you do over there?
The gigalaw.com website has been around now for about 10 and a half years and has undergone some changes through the years, like everything else. But today essentially provides daily news clips to most of the important internet and high-tech legal issues like those that we've been talking about during this hour. And there's also an archive there of the past several years, not all 10 years, but the past several years, about 5,000, 6,000 news clips on everything from patent, copyright, and trademark to privacy and antitrust and free speech and all these other issues that we've been talking about. So sure, feel free to drop by the gigalaw.com website, sign up for the RSS feed or a daily email. Take your pick.
And then our other resource of the week will be courtesy of James, his blog, laboratorium.net. James, you've been writing that for as long as I've known of you, when you were way back in law school. And is that where you do most of your writing about the book search settlement, or do you have another separate site for that?
No, I do most of my Google book search blogging at the Laboratorium, which just turned 10. So I'm very happy about that. And
congratulations.
It's primarily a personal blog, because I write about things that have nothing to do with technology and law. But since I'm a law professor who teaches about technology law, it winds up that a lot of the things I find interesting turn out actually to be cases and issues in law and technology, intellectual property, privacy, search engines, virtual worlds, all sorts of great stuff. And so for the last couple of years, I've been using it to write a great deal about the Google book search case. And so I just try to run news updates with I put GBS in the post title, so people who find the case boring can skip right past it. I try to run whatever happens. People write papers about it, new developments in the case, new interesting blog posts. I link to them and comment on what's happening. So that's really, I like to think of it as the best home for keeping up to date with the settlement. It's been a little slow lately, of course, since there's not much happening with the case off with the judge, but when something happens, we'll be there to cover it.
Right, and I just typed lawmeme.org and lawmeme.net into my search bar and got parking pages at GoDaddy. Does lawmeme still exist in any way, shape, or form?
It's not active, but it's archived. The URL was never actually lawmeme.net. It was officially research.yale.edu/lawmeme. And if you go there, we should still have an archive of all of the articles.
Wonderful. So that's definitely worth taking a look at as well, simply because it's a historical document of when folks first started discussing, I think, in a substantive way online, the kinds of issues that we discussed on this show. So thanks so much, James, for your involvement in all of that, and for your work with New York Law School and your work with Yale Law School in the past. And thanks so much for coming on the show.
It's been a great pleasure. Thank you for having me.
Folks can find James on Twitter as well at GRIMMELM would be your Twitter handle, correct?
Yep.
Grimmel.
First 8 letters my last name.
Yes. Or if you just do James Grimmelman Twitter into your favorite search engine, you will find him that way. And also, of course, laboratorium.net. So wonderful to have you. Hopefully we can do that again sometime.
I'm looking forward to it.
Good. Doug Eisenberg, also someone that I've been dying to get on the show. So I'm thrilled we were able to make that happen. And you are also Doug Eisenberg on Twitter.
That's right.
Right.
Thanks for having me again. Yep, that's exactly right.
And Gigalaw has its own Twitter account if you'd just like to follow the news hits that come through on your great site at gigalaw.com. So again, thanks for coming on the show, and hope to have you back again at some point in the future.
Great. Thank you, Denise.
And Evan, I hope to have you back all the time, as we love to have you on sharing your various past indiscretions on the show as often as possible.
Right, and I can always come up with more of those, I think. So, yes, great to be here. Always a good time. Thanks for the returning invitation. And James and Doug, it was a lot of fun talking with you. James, I enjoyed meeting you this past February when we spoke at that symposium in Pennsylvania. And Doug, I feel like I've gotten to talk to one of my heroes. I remember reading Gigalaw way back in the day. That would have been in the 56K modem era.
I thought you were going to say in 1956, and no, I haven't been online that long.
Right, and the internet law issues back then were really compelling as well in 1956. So. But Gigalaw is a resource that I've been using for a long time. So it's great to finally meet you, so to speak.
Great. Well, thanks. It's great that there's this wonderful community of folks who are unearthing and talking about all of these important and fun issues as well.
Yes, lots of fun.
And Evan always talks about those issues and other fun things in his Twitter stream at Internet Cases on Twitter. And, of course, check out his blog at internetcases.com. Folks can find me on Twitter. I'm at dhowell. Or send me an email after the show, denise@twit.tv, with any questions or comments you may have. And you can also visit my site, bagandbaggage.com, where I put up the videos from the show when they become available. They're also available on YouTube, in iTunes. If you go to our show page at Twit, you can find various ways of subscribing that hopefully work well for you. And, of course, you can watch live Fridays at 11 at live.twit.tv. So thanks, everyone. It's been a fun show, and we will see you next week. Take care.